Hello, my name is Clifford Edok, a law student. This video is part of my learning and at the same time bar review in taxation. So in this video, I will delve into the intricate world of tax remedies, focusing on the critical aspect of due process in administrative and judicial remedies available to taxpayer. Whether you're a tax professional, business owner, a law student, or simply curious about your rights, I hope this video will help you empower with essential knowledge as I am too through the process of teaching. So disclaimer, before I proceed, under no circumstances should it be assumed that this video or this video I am presenting to you constitutes legal or business advice. This information is provided solely for educational purposes, and it should not be considered a substitute for proper legal advice or for thorough study and comprehension of the law. And furthermore, before I continue, please subscribe to my channel if you find this video very useful and informative. Thank you. Now, I will be discussing the following topics. Number 1, discussion of discrepancy in tax assessment. Number 2, uncover the details behind preliminary assessment notice or PAN and final assessment notice FAN issuance and the consequences of failing to respond within the specified prescriptive period. And number 3, explore the process of addressing discrepancies through formal protest, identifying the key elements required for a valid protest. Additionally, we're going to learn how the final decision on disputed assessments or FDDA impacts the assessment's finality and to understand the timeline for appealing to the CTA or Court of Tax Appeal. So navigating these options available will be very challenging, and I hope you will stay with me for the few couple of minutes. So let's start with letter of authority. The letter of authority serves as a critical document in the realm of tax assessment. For brevity, LOA is an official authorization granted by the Commissioner of Internal Revenue or their authorized representatives. It empowers designated revenue officers to perform assessment functions within a specified jurisdiction. For example, to examine the books of account and other accounting records of a taxpayer for the purpose of collecting the correct amount of tax. The NRRC in Section 6A explicitly restricts the authority to examine and assess taxpayers for the correct amount of tax to the CIR and authorized representatives, the deputy commissioners, assistant commissioners, and head revenue executive assistants. And by way of exceptions, under Section 10, letter C of the Tax Code, allows revenue regional directors to issue LOAs, letter of authority, to revenue officers within their regions. Thus, the issuance of an LOA hinges on the understanding that examining a taxpayer who has already filed tax returns is a power statutorily reserved for the CIR and authorized representatives. In recent, this is 2022, promulgated on April 22, 2022, decision CIR versus EDS Manufacturing Inc. CTA EB number 2411, the CTA emphasized the importance of a valid LOA. The CTA nullified the final decision on disputed assessment FDDA issued against the taxpayer and canceled the tax assessment worth 223.8 million of the taxpayer because the names of the revenue officers who actually examined and recommended the PAN, that's the preliminary assessment notice, were not found in the letter of authority. The CTA held in that case that the LOA is the concrete manifestation of the grant of authority bestowed by the Commissioner of Internal Revenue or his authorized representatives to the revenue officers. The LOA gives notice to the taxpayer that it is under investigation for possible deficiency tax assessment, and at the same time, it authorizes or empowers designated revenue officers to examine, verify, and scrutinize a taxpayer's books and records in relation to internal revenue tax liabilities for a particular period. Hence, the absence of such an authority renders the assessment or examination a patent nullity. So there should be a notice of discrepancy or NOD, issued to inform the taxpayer of the deficiency findings made by the revenue district officer on its books of accounts. The notice of discrepancy was formerly known as NIC or Notice of Informal Conference. This notice of deficiency is followed by a discussion of discrepancy. The taxpayer may or may not attend this discussion. This shall not exceed 30 days from receipt of notice of discrepancy. If the revenue officer did not accept the taxpayer's explanation or the documents presented, the CIR shall not issue the PAN, Preliminary Assessment Notice, the proposed assessment in compliance with due process. The PAN or the Preliminary Assessment Notice is a notice issued by the Assessment Division of the BIR to the taxpayer done after a review is conducted of the case submitted by the revenue officers finding that there exists sufficient basis to assess the taxpayer with deficiency taxes. This proposed assessment shall show in details the facts, the laws, the revenue and regulations, and jurisprudence on which the proposed assessment is based. The taxpayer is given 15 days from receipt of the PAN, Preliminary Assessment Notice, to respond. Otherwise, it shall be considered in default. That's found in Section 228 NRC and the Revenue Regulations 18-2013-2013, which amended Section 3.1.2 of the Revenue Regulation number 12-99 as amended. The preliminary assessment notice is not mandatory and the protest to preliminary assessment notice is optional. So here, the reference is RMO or the Revenue Memorandum Order number 26-2016, clarifying the Revenue Regulations number 12-99 as amended. If the taxpayer fails to respond within the 15 days from the date of receipt of the PAN, Preliminary Assessment Notice, he shall be considered in default, in which case the FAN, Final Assessment Notice, with FLD, Formal Letter of Demand, shall be issued calling for the payment of the taxpayer's deficiency tax liability inclusive of the applicable penalties. PAN or Preliminary Assessment Notice is not required and Final Assessment Notice FAN, along with the formal letter of demand, shall be issued outright in the following instances. So these are the exceptions. Letter A, when the finding for any deficiency tax is the result of mathematical error in the computation of the tax as appearing on the face of the return. Or letter B, when a discrepancy has been determined between the tax withheld and the amount actually remitted by the withholding agent. Or letter C, when a taxpayer who opted to claim a refund or tax credit of excess creditable withholding tax for a taxable period was determined to have carried over and automatically applied the same amount claimed against the estimated tax liabilities for the taxable quarter or quarters of the succeeding taxable year. Or letter D, when the excise tax due on excisable articles has not been paid. Or letter E, when the article locally purchased or imported by an exempt person such as but not limited to vehicles, capital equipment, machineries, and spare parts has been sold, traded, or transferred to non-exempt persons. That's found in Section 228 National Internal Revenue Code. If the CIR or the Commissioner of Internal Revenue issue final assessment notice FAN without awaiting the protest to the preliminary assessment notice PAN by the taxpayer, the final assessment notice FAN is void as it violates the taxpayer's right to due process. Section 228 of the NIRC gives the taxpayer a period of 60 days from the date of filing a protest for reinvestigation to assail the preliminary assessment notice and to submit relevant supporting documents. The final assessment notice fund received by the taxpayer a day after it filed its protest violates the latter's right to due process as it has only 1 day instead of the 60 days to present its relevant documents. Thus, in the case of CIR versus RUCA Security and Investigation Agency Inc., GR numbers 241338, April 10, 2019. The CIR issues final assessment notice which specifies the amount and the basis for the assessment, including the relevant facts, laws, revenue regulations, and jurisprudence. To determine whether the CIR's course of action has prescribed the 3-year period for assessment is counted from the filing of the tax return to the date of final assessment notice issuance. Once this period has elapsed, prescription has occurred. The final assessment notice fund may be accompanied by formal letter of demand, which must also state the basis of the computation, relevant facts, laws, revenues and regulations, and jurisprudence. Taxpayer must file a protest within 30 days from receipt of the final assessment notice or formal letter of demand, either through motion or request for reconsideration or request for reinvestigation. The requisites in filing a protest are the following. A. The protest must be in writing. Letter B. Addressed to the CIR or its representative. The taxpayer shall state in its protest the number 1, the nature of protest, whether it is a request for reconsideration or reinvestigation, specifying newly discovered or additional evidence he intends to present if it is a request for reinvestigation. If it is not indicated, it will be considered a request for reconsideration. Number 2, the date of the assessment notice. And number 3, the applicable law, the revenue and regulations, and jurisprudence in which his protest is based. Otherwise, his protest shall be considered void and without force and effect. If the issues which the taxpayer did not protest or fails to state the facts, the applicable laws, the revenue and regulations and jurisprudence in support thereof shall be considered undisputed, in which case the assessment attributable thereto shall become final, executory, and demandable. The taxpayer shall be required to pay the deficiency tax or taxes attributable thereto, and a collection letter shall be issued to the taxpayer calling for the payment of the said deficiency tax, inclusive of surcharge and or the interest. Only those protested and duly supported shall be considered under dispute. Section 228 NRC and found in Revenue Regulations number 18-2813, which amended Section 3.1.5 of the Revenue Regulations number 12-99 as amended. If the taxpayer fails to file a valid protest against the final letter of demand or the final assessment notice within 30 days from date of receipt thereof, assessment shall become final, executory, and demandable. No request for reconsideration or reinvestigation shall be granted on tax assessment that had been already become final, executory, and demandable. The CIR issues FDDA or final decision on disputed assessments within 180 days from the filing of protest. It constitutes the final decision of the CIR on the protest filed. This is the decision of the CIR or his or her duly authorized representative on the protest filed. It shall also state the facts, applicable laws, revenue and regulations, and jurisprudence on which such decision is based, and that the same is his or her final decision. This is the disputed assessment that is brought before the CTA. The actions of BIR is either to grant, deny, partially grant or deny the assessment, or will sit on it for 180 days. And lastly, or in the case of request for reinvestigation, the taxpayer may be required to submit supporting documents within 60 days from the date of filing the letter of protest. In case of denial, the taxpayer may appeal to the CTA in division within 30 days from denial thereof or file with the CIR a request for reconsideration, but this will not toll the 30 days period to appeal the CTA in division. In case of inaction by the CIR, taxpayer may appeal to CTA within 30 days from the lapse of the 180 days. Or the other option is to wait the final decision of the CIR even beyond the 180 days to decide. In case of denial of protest, taxpayer may within 30 days appeal to CTA. Due process must be observed in each of these steps in the issuance of LOA, letter of authority, notice of deficiency, the PAN, the preliminary assessment notice, final assessment notice, and the formal letter of demand up to the final decision of discrepancy assessment. The CIR and the revenue officer must strictly comply with the requirements of the law, with the BIR's implementing rules and regulations, and with due regard to taxpayers' constitutional rights. Request or motion for reconsideration is a plea of re-evaluation of an assessment on the basis of existing records without the need of additional requirements. All protests shall be considered a request for reconsideration unless said protest indicates that the request is for reinvestigation. It is still considered validly filed if the protest was filed without an indication if it is request for reconsideration or request for reinvestigation. Motion or request for reinvestigation is a plea for re-evaluation of an assessment on the basis of newly discovered or additional evidence that a taxpayer intends to present within the 60 days from date of filing. It may involve a question of fact or of law or both. So that's found again Section 228 and the revenue regulations previously mentioned. The filing of either request for reconsideration or request for reinvestigation precludes the filing of the other. That's RMO Revenue Memorandum Order number 26-2016 clarifying Revenue Regulations number 12-99 as amended. The assessment shall become final and executory in the event the taxpayer fails to submit the relevant supporting documents within the 60-day period, and a collection letter and other collection remedies shall be issued against the taxpayer. Take note that the submission of documents does not apply in request for reconsideration. The Commissioner of Internal Revenue CIR is given 180 days counted from the date of filing of the protest to act and to decide on the protest or administrative appeal filed by the taxpayer. Upon the lapse of these 180 days, the taxpayer has 30 days to resort to judicial remedy by filing an appeal with the CTA in division. However, the taxpayer also has the option to wait for the CIR's decision even if this will be made beyond the 180 days. Then file the appeal from receipt thereof. This should not be confused with the 90 days period of the CIR to decide tax refund or tax credit cases of input VAT credits. This should be for another video soon. And that's it. Thanks for watching and thank you for subscribing to my channel. This is Clifford. I'm out.